Miscellaneous file number 678, 2026, Stephen Elias. Stephen Elias. Miscellaneous file number 677, 2026, Honorable Mutai Kiprono Alfred.
Matrix, Your Honor, in that matter. I do appear. My name is Lawrence Karanja, together with Mr. Steve Biko Osul,
Present.
Mr. Guto Ongechi,
Your Honor, I'm present.
and Mr. Asab Cheriot.
Your Honor, I'm present. Hassan?
Cheriot, Asab Cheriot. We appear for the respondent.
I believe Mr. Hassan has an injury on the head. Yeah, that is why you have taken. Yeah. Sure. Okay, allow. Where is the respondent? Honorable Mutai Kiprono Alfred. The other one. Respondent present. Yes, Miss.
Good afternoon, Your Honor.
Afternoon, Miss Boyon.
Yes, Ms. Boyon, for the state applicant.
Yes, Miss Boyon.
So before you is an application dated 23rd of June 2026. In which you are seeking custodial orders, 21 days custodial orders. To remand the respondent pending completion of investigations. The investigating officer is in court.
Yes, this one is Magai.
Yes. Proceed.
I swear by the name of the Almighty God that the evidence shall give this before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God. Your Honor, I'm number 240 538, Inspector Polycarp Magai. Currently, the in charge DCI could say Your Honor, in regards to the incident, the matter before you, I wish to state that Your Honor, on 19th day of June 2026, at about 10 a.m. in the morning, the First Lady, Her Excellency, the Governor of Nakuru, Susan Kihika, had organized for an empowerment of youth and women within Kuresoi North constituency, and the venue was Umoja Senior School. Your Honor, we were mandated with the responsibility of providing security during this day. Your Honor, on this material day, we arrived at the venue early enough, ready to provide security for this function that had been planned prior. Your Honor, members of the public arrived at the venue as early as 6 in the morning. And Your Honor, at around that 10 a.m., the area MP, Honorable Alfred Mutai, arrived at the venue while accompanied by his followers. And Your Honor, at this particular time, the followers were built and rowdy. Thus, the security officers intervened. Your Honor, in the process of intervening, the other supporters who had settled at the venue came towards the direction where the Honorable Member was, just around the entrance for the main gate, and saying that the Honorable Member of Parliament had not been invited into this function for that material day. At this point, Your Honor, things turned chaotic, and commotion erupted. Your Honor, the Honorable Member, together with his followers, were not allowed to reach at the venue. Thus causing commotion. And Your Honor, in the process of this, some members of the public were shot. Some got serious injuries and are still admitted at various hospitals within Nakuru County. Your Honor, eventually, the Honorable Member, together with his team, left the venue and went back. At this particular time, Your Honor, since the situation was not conducive for the security team to effect an immediate arrest, we traced the suspects on the same day and eventually found a number of them, totaling to about 56, within the residence of the Honorable Member of Parliament. Your Honor, unfortunately, but that particular time, the Honorable Member of Parliament was not within his residence. Your Honor, we brought the arrested group suspects to Nakuru police station, whereby, Your Honor, they appeared before court yesterday. We then summoned the Honourable Member of Parliament to appear at any nearest police station of his choice. And for this matter, Your Honor, the Honourable Member of Parliament opted to report at the CCI's office, Nakuru, yesterday at about 8:30 in the evening. Your Honor, we took his statements, and Your Honor, we inquired with him about his civilian firearm, but by yesterday he was not having the firearm. So, Your Honor.
And all this contained in your affidavit?
Yes, Your Honor. Your Honor, the reason why we are appearing before you this afternoon is that we are seeking for more time, at least 21 days, to conduct and conclude our investigations and Your Honor, it is our request that in the course of our investigations, the Honourable Member of Parliament be compelled to surrender to us his firearm for the purposes of ballistic examination. Your Honor, I also want to bring to attention of the court that during the incident that occurred on the 19th day of June 2026,
19th of June?
19th of June 2026, we were able to recover spent cartridges of our ammunition, one bullet head, and one unspent cartridge. One unspent bullet, I'm sorry, Your Honor. Your Honor, it will be fair for us and to the respondent if he surrender the firearm to us for the purposes of ballistic examination, Your Honor, it is also our wish to retain the suspect in police custody for one good reason. The victims who were shot on that particular day sustained serious injuries and are still admitted at various hospitals up to date. Your Honor, the same victims are the witnesses, key witnesses we are relying on in this matter. And Your Honor, it is their fear that if the respondent is released, they may not be safe. Your Honor, another fact is that considering their condition at this particular moment, we were unable to record their statements. Concerning the fact that their condition still cannot allow them to do so. Your Honor, another fact is that the victims who are also our witnesses some of them are not from Kuresoi South, North Sub-County, and therefore we may need to conduct an ID parade on this matter. For us to be certain and the witness to be sure of themselves, Your Honor. Your Honor, during this criminal incident, a minibus registration number KDQ 155G belonging to Ngata Welfare Community Group was completely burnt down. Your Honor, the official vehicle, government vehicle, assigned to the DCC Kuresoi North was maliciously damaged. The Toyota Prado VXL registration number KDV 444A was also maliciously damaged. Your Honor, we need to get evaluation report in regards to these damaged vehicles. So that, Your Honor, eventually, if in case we may prefer charges against the respondent, it will be clear for us to have the value of the damaged property. Your Honor, down on the ground within the constituency, the tension is still high. And it is our wish, Your Honor, our prayer, that the respondent be kept within the police custody for the stated period of time. As we conduct the investigations. And also to enable the victims who are our key witnesses to recover and be in a position whereby they'll be able. Okay, sorry, Your Honor. So that's all, Your Honor.
Ms. Boyon, you want to add anything before I call upon the councils representing the...
Probably just to submit that the grounds are advanced are sufficient to tilt the discretion of the court in our favor and allow the application as prayed. And also that no prejudice will be occasioned if the application is allowed. That's all.
So I don't know whether the senior most will start.
Yes, I'll start a few questions for termination. Then Mr. Ruto will ask a few questions. Then from there, myself and Mr. Nicholas will.
That is Mr. Karanja.
And we'll be very brief. I want to ask you a few questions. Inspector Mutai.
Yes, Your Honor.
Investigations are ongoing.
Yes, Your Honor.
It is upon conclusion of investigations that you'll decide who is to be charged with what offense.
Sure, Your Honor.
As of now, you have not made up your mind who will be charged, isn't it?
Very true, Your Honor.
And when you have not made up your mind who will be charged, you want Honorable Mutai to be in custody for 21 days as you think on who you will charge.
Yes, Your Honor.
Okay. Now, let's go to the question. You have said you intend to conduct valuation of the burned and damaged motor vehicles.
Yes, Your Honor.
How will Mr. Mutai, being in custody of the police, assist you while doing the valuation?
Your Honor, we've indicated before this court that currently
Assist you or prejudice your variation. The first ground is that you have to do variation. Will it in any way affect your variation?
yes, Your Honor,
How?
because the valuers will need to go to the ground
Yes.
where the incident occurred,
Yes.
and the damaged properties are still on the ground, the same ground we are talking about.
Right.
And Your Honor, allowing the Honorable Member of Parliament to go back to the ground may in one way or another interfere with this investigation.
Mr. Nagai.
Since he's a Member of Parliament with the followers who are also living on the same ground.
Therefore, you want to say that you cannot access Kuresoi North constituency if Honorable Mutai is not in police custody.
Come again?
You cannot access Kuresoi North constituency if Honorable Mutai is not in custody.
Your Honor, we can access.
You can
Kuresoi
access.
if
That's my question. You
currently
can
in
access.
custody.
You can access even if when it's in custody. You went to arrest people at his homestead.
Yes, Your Honor.
You did, isn't it?
Yes, Your Honor.
Was he in custody?
He was not, but
He was not
he
in
was
custody.
not within the constituency.
He was not in custody, but you are able to arrest 16 people, not within his constituency,
26.
at 26 at his home when he was not in police custody.
Upon confirming that he was not within the constituency.
So you are cowards. You first of all find out whether he's there, then you go there.
This is a
Yeah.
matter of being coward.
No, you first of all make a call, confirm if Honorable Mutai is there, then you go there. As long as he's there, you cannot go there.
Your
Is that
Honor,
what you are saying?
No, Your Honor.
So you can go there even when he's there.
Upon assessing the situation.
Once you assess the situation, you can assess.
If the scene will be conducive, well and good.
Or even if you were to get reinforcement, you cannot assess.
Your Honor, there are so many factors to consider before doing that, Your Honor.
Let's go. So the valuation, who is supposed to do the valuation?
Government valuer.
Government value. Where are they situated?
Your Honor, the valuers are in Nairobi.
I want to inform you they are in Nakuru. There is a Department of Public Works and Motor Vehicle Inspection. They are there. We have competent valuers here in Nakuru if you don't know.
Your Honor, for this matter, we may prefer doing it in Nairobi.
Or the one in Nakuru are unqualified.
Not a matter of being unqualified.
Why? Why would you want those from Nairobi? Tell us.
For the reasons that I may not disclose before this court.
So a valuer from Nakuru cannot do a valuation of a vehicle in Kuresoi. You need to get one from Nairobi for reasons you cannot disclose.
Yes, Your Honor.
Okay. So you think the one in Nairobi are more qualified than the one in Nakuru?
That is your suggestion, Your Honor.
No. Why would you want one from Nairobi? A valuer is a valuer.
Yes, Your Honor, but I've said for the reason that I may not disclose before this court.
So for that reason you may not disclose. That cannot be a basis of detention of a member of parliament unless it's a reason you are disclosing. That is your reason.
No, Your Honor.
Let's go to the issue of the recover of his firearm. I've heard you making an application that he be ordered to surrender his firearm. Have you made that application before this court? In this application? Is there such a prayer before court?
Yes, Your Honor.
Why is it? Show me. You have 3 prayers. Prayer number 1, it will be admission. Number 2, issue an order for remand to complete investigation. And number 3, there have been orders cost. Those are your 3 prayers. Those are your 3 prayers. So you don't have a prayer before court for him to surrender his firearm.
We captured that point, eh?
I'm showing you application. You know this is now law. In law,
Probably can assess the consider that
yeah, you know where it is in the application? Inspector, you see this?
Under prayer number 3.
Which one?
Number 3. That there be no order as
That you are on prayer number 3 is this. So these are your 3 prayers. So there is no prayer for him to surrender his firearm. Okay? Now let's go to the question. Honorable Mutai is a licensed firearm holder, isn't it?
I'm not sure, Your Honor. I've not seen the license.
But you are the one who is asking for him to surrender, so you don't know whether
It may be licensed or not.
do you know whether he has a firearm?
Yes, I know that.
Which one? Licensed or unlicensed?
That is what we confirm.
So you want somebody to surrender, you think somebody can surrender unlicensed. So I want to put it to you that Honorable Mutai is a licensed firearm holder. So with that information, if you know that he's a licensed firearm holder, what would you do if you want him to surrender?
Your Honor, I've not seen the
I'm asking
certificate, so
if-
I cannot go by what the council is saying.
Suppose he's a licensed firearm holder, how will you deal with it?
Your Honor, I don't know whether it will go with supposing or will go with facts.
Okay,
But-
fine. You are an officer.
Yes, Your Honor.
You know the process.
Yes,
That's
sir.
exactly
Yeah.
what council is asking.
Your Honor, the main reason why we need this firearm,
Is it the process you want to know?
I want the process. If you want him to surrender the firearm, what is it? And he's a licensed firearm holder, what process would you follow?
the process are laid down, which, unless given time, I may go.
You may not know the process. Okay, let us go. So your process is in detention for 21 days. Now, for 21 days, you want him in the police station.
Yes, Your Honor.
How will Honorable Mutai get his firearm and certificates and bring them to you, whereas you want him to be in police custody?
Your Honor, the firearm, if given authority through any other person, can reach the police station.
Or through any other person,
Yes.
it can reach the police station.
Yes, Your Honor.
I want to ask you a question. You know the conditions under which are attached to issuance of a firearm. Do you know that you're not supposed to give that firearm to another person other than a police officer? So he can't tell his spouse, he can't tell a neighbor to come and bring the firearm to the police station. It is only him who can hand it over.
Your Honor, the Honourable Member of Parliament have been assigned police officers, and in any case, you can use the same police officers to get the firearms to us or to any nearest police station.
Yesterday, who called him? He was called by CCI, Mr. Gaiwa.
I'm not aware, Your Honor.
But you've heard he surrendered himself.
Yes, Your Honor.
He was called. Are you aware whether he was told to come with his firearm?
Yes, Your Honor, I'm aware.
Who told him?
I got him.
You have said you don't know who called him.
Yes, Your Honor.
So who is this one who told you?
I got this information from the office.
Who is the officer who told you?
Your Honor, I'll not be in a position to tell that.
You see, now you want us to lie. You have said you don't know who called him.
Yes, Your Honor.
But you know somebody told him to come with a firearm.
Yes, Your Honor.
And you want the court to rely on your hearsay. You are told somebody told him. My instruction is that nobody told Honorable Mutai to appear or to surrender his firearm. You know the court, even if he's given bond, he can still be ordered to come and surrender his firearm. You know that?
Yes, Your Honor.
Okay. So, let's go to the third ground, which you have put, is that you intend to record statement of key witnesses who are undergoing medication and in critical and unresponsive condition, correct?
Yes, Your Honor.
Do you have any medical report before this court to show that any of the victim is in hospital, or even a letter from any hospital? Do you have any?
Your Honor, it was...
I've asked you, do you have
We don't
any?
have currently.
You don't have
And
anything?
it was not possible for us, as was advised by the doctors.
I've not asked you. I've asked you a letter from the doctor to say we have admitted patient so and so who is going through treatment. You don't have such a document, correct?
For a reason that I've given, Your Honor.
You have also said that you intend to carry out identification parade because some people don't come from Nakuru, isn't it?
Yes, Your Honor.
How will he being out affect the identification parade? Or do you know what is an identification parade?
Your Honor.
So how will he being out interfere with identification parade?
Your Honor, normally, when conducting an ID parade,
Yes.
the suspect is not supposed to be seen by the witnesses before an ID parade is conducted.
Mm-hmm. That is to safeguard the integrity of the parade, correct?
That is true.
Now, how will Mr. Honorable Mutai know who is the suspect? You can't call him here at DCI. When he is there, you call the identifying witness and tell 10 people, 9 people, and ask them, identify the person you saw.
Your Honor, the names of the victims are currently in the public domain.
The names of?
The victims, or the witness we are relying on.
So what is the problem with that?
And Your Honor, allowing Honorable Mutai to go back to the constituency may not enable us get a fair
Identification
ID parade that we intend.
I want now to go to that, Mr. Polycarp Madai. Honorable Mutai is a public figure.
Yes, Your Honor.
Is a member of parliament.
Yes, Your Honor.
He has served in the county assembly. You don't know that? He was a former MC in Nyota.
Yes, I know that, Your Honor.
If you Google your phone now, Honorable Mutai, you'll see his photo. Or you want us to try? You just Google Honorable Alfred Mutai. You'll check, you see the figure, and you look at the gentleman. You'll see his face. Is he not a public figure?
Your Honor, yes.
So this is somebody anyone from Nakuru would easily identify.
Your Honor, but not everybody from Nakuru.
Or some of the victims are not from Nakuru.
Yes, Your Honor.
They are from where?
Outside Nakuru.
What have they come to do for empowerment in Kuresoi?
Your Honor, Nakuru is important because...
You have said from Nakuru, they are outside Nakuru. Those are the people actually you should have arrested. Those are the goons who have been brought from outside Nakuru
We don't
to
have
attack
rules
Honorable.
restricting any other member of public from coming to Nakuru or any other county.
Okay, you don't restrict, isn't it?
Yes, Your Honor.
And you have said it was an empowerment program.
Yes, Your Honor.
And you have said Honorable Mutai was restricted from a member of parliament from assessing. You are the one who has said he was restricted from assessing.
Your Honor, I use the term that he was not invited, not restricted.
But you said, you have also said, and it is on record, that they told Honorable Mutai he was not supposed to be in that, the other group which came. And they were departing him. What did they tell him?
That you are not invited to this function.
You are not invited in a function in your constituency. In your own constituency. A public school. In a public school, the honorable member of parliament of that constituency was not invited.
But a function organized by her Excellency the Governor.
And by the way, have you recorded her statement? Now that you have mentioned her. Have you recorded the statement of Honorable Susan Keka?
Yes, Your Honor, the office has done that.
You have the statement?
Not here in court.
Are you sure you have recorded the statement? Did you record the statement?
Not me, but the office has done that, Your Honor.
Which office?
The DCA office.
Nakuru or Krisoi?
Within Nakuru.
Which, at the CCI office?
Yes, Your Honor.
So there is a statement by Honorable, should be one of the witnesses.
Eventually, when Your Honor, if we prefer a charge against the Honorable Member of Parliament.
If you prefer.
Yes, Your Honor.
If you prefer. And I want, there are just two questions I would want Mr. Magaya to, the last two.
The only one, Mr. Sando. Now, I want to ask you some few questions. There's a place that you have indicated that Honorable Mutai will interfere with witnesses. Is that true?
True, Your Honor.
So, are you the investigative officer in this case?
Yes, Your Honor.
Have you received information from any person that Mr. Mutai has interfered with him?
Your Honor, we get intelligence reports on a daily basis, and some of these reports are not shared in public.
Now, because that is your affidavit, have you attached that intelligence report?
Your Honor, for the good reasons that I've mentioned before this.
No. You know, my question is yes or no.
No, Your
I've
Honor.
asked you whether you have.
No, Your Honor.
Do you have any phone call from any person that Honorable Mutai has interfered with him, that Honorable Mutai tried to call this person?
Your Honor, I don't have a phone call.
Do you have any email address?
No, Your Honor.
So where are you getting all this information from?
Your Honor, I've indicated to this court that we majorly rely on intelligence.
Which is not before court. And you also understand that this is a court of law that is governed by evidence, is governed by the law. Is that true?
Correct, Your Honor.
So you want the court to believe on whatever you are saying without providing any evidence? So that's what you want to say?
No, Your Honor.
So you want the court to, so on what basis is Honorable Mutai interfering with witnesses? If they have not, he has not tried to contact them, the witnesses have not contacted him, on which way is he interfering?
Your Honor, he may interfere in this way, Your Honor. Your Honor, up to this point, we've done several statements from other witnesses.
Which you have not attached in your affidavit? Have you attached them in your affidavit?
No, Your Honor. But in those statements, Your Honor,
Now,
the witnesses indicated.
okay, you have already answered that question. Now let us proceed. Now, there is another point, to allow the victim, who are still admitted in critical condition, to be taken through medical examination to ascertain their respective degree on injuries and to record their statement. Okay. Is Honorable Mutai a doctor?
No, Your Honor.
He's not a doctor.
But I'm not sure.
So how is he going to interfere? How is he going to interfere with this, or to allow the victim who are still admitted in critical condition to be taken through medical? How is he going to interfere with that?
Your Honor, the witnesses are admitted in public hospitals, which can be accessed by anybody, including the Honorable Member of Parliament.
So has any of them called you to say that Mr. Mutai will go there?
Your Honor, we visited these patients and they've been telling us that their lives are in danger.
No, leave that alone. The last point, to allow ample time to conduct fair and conclusive investigation into the offense committed, bearing in mind the gravity of the charges to be preferred. Again, on that, I'm asking you a question. How is, because can you confirm that it is the police that are conducting the investigation?
Yes, Your Honor.
And you are armed? Is that true?
Yes,
Police
Your
are
Honor.
armed.
Yes, Your Honor.
And also understand that in Kenya, only the police have got the monopoly to use violence?
I'm not aware of that, Your Honor.
You're not aware?
I'm not aware of that.
So Mr. Mutai is going to interfere with the police. He's not going to give the police ample time to conduct investigation. Is that what you're trying to do?
Your Honor, that point is very clear.
No.
And
No,
our
I'm asking
main
you.
intention of objective here
No.
is to have a fair investigation on both sides.
What is the question?
So I'm asking you, because these are police officers. You are the one conducting investigation. Is that true?
Yes, Your Honor.
And you are saying that Mr. Mutai, a civilian, is going to interfere with the police while they're conducting investigation. Is that what you're trying to tell the court?
Yes, Your Honor.
And to the best of your knowledge, does Mr. Mutai know the witnesses that you intend to rely on in this case?
Some of them.
You know them.
Some of them.
How do you know that Mr. Mutai knows those witnesses?
I know this because, Your Honor, even by the time he was doing a statement, he could mention some of the victims.
Do you have that particular statement before God?
His own statement, which,
No, I'm saying, do you have it?
Your Honor, I don't have it now.
Okay, Your Honor, that is all for this witness.
We want to make very brief and humble submissions. First, the application before you is, and it has been held so by, Lord, I want to, Your Honor, to give you an authority by Honorable Justice Kimaro, now Judge of Appeal, in the case of Michael Rotich versus Republic, miscellaneous criminal 304 of 2016. You know, you can.
I'll get it.
I'll get it.
I'll
Yes.
try and get it.
Yes. It's a very brief one at page 4, that position where the judge said that, as stated earlier in this ruling, the recent trade where a person is arrested and arraigned in court within 24 hours, specifically for police prosecution to seek extension of time to continue detaining such person without any charge or holding charge being verified against such person, is unconstitutional. What they are trying to do has been found by the High Court to be unconstitutional. And this is based on reason, you know, that the liberty of a person is extremely precious. And it's a priceless treasure. It can only be taken for good and comparable reason. Before you, Your Honor, is an application where the police have said they may or they may not charge the accused person. They have not made up their mind. But as they make up their mind, Your Honor, you are been told, keep this man in our custody. Look at the grounds which are being advanced. None of them is sufficient. Valuation. What will the Member of Parliament have to do with it? Your Honor, you are being told about that they need to examine his gun. What will that do with the investigation? He just surrenders his firearm. They carry out the ballistic investigation. He doesn't need to be in the police custody. They have not said that he is part and parcel of the ballistic examiners, so that he'll be interfering with that. You have been told, Your Honor, pure hearsay, that there are people in hospital. And based on that, without a single document, you are being told, detain this person. And I got it from the investigating officer, what he said. He said that some of the people in hospital have expressed their fears. So these are people who are able to talk, people who are able to speak. When convenient to the IO, they speak. When it's not convenient, they become dumb and you're supposed to detain Honorable Mutai. Again, if you look at the grounds you are being told that that they need to carry out an ID parade on Honorable Mutai. I think that is the joke of the century, that you need to keep him somewhere and then you call people to identify him. These are people who are saying they don't know you. They will just inquire. And in fact, if there is an ID parade, which I don't know will serve any purpose, is trying to identify Honorable Mutai. This is a public figure. I may not have met personally, but if I see him, I will identify him. So anybody who says he doesn't know Honorable Mutai and had gone to Kuresoi too, and they are saying this is a person who was not wanted. They knew whom was not wanted. So that is not a ground. Again, Your Honor, the very fact that my colleague, the prosecutor, has said that no prejudice will be made. The suspect will suffer no prejudice. Are you sure? A member of parliament being detained for 21 days, and there will be no prejudice. His liberty being curtailed for 21 days, and there is no prejudice. There can be no greater prejudice than denying somebody his liberty. Your Honor, as I finish that, I can hand over to Mr. Biko. Honorable Mutai exercises powers under Article 2 of the Constitution, which says power can be exercised directly or through elected representatives. Honorable Mutai exercises that power on behalf of 159,000 residents of Kuresoi North. They will remain without a representative in Parliament for 21 days as the police officers carry out their investigation to make up their mind that they may not, because I know the conclusion will be there is no sufficient evidence, but they may find out that there is no sufficient evidence, so that they make up their mind. The people of Kuresoi North will suffer because of detention and incarceration of their elected member of Parliament on such flimsy ground. I would urge Your Honor to go by what Justice Kimaru did in this matter. Justice Kimaru said, before he penned office, he ordered that suspect, he gave him bond and told him to comply and to appear before the police officers as and when required. In fact, for Honorable Mutai, being an honorable member of Parliament, give him his personal cognizance. He was summoned yesterday, he appeared. He doesn't have to deposit even a single shilling to appear before a police officer. Anytime he's called, he has informed me he is ready and willing to appear before any police officer anywhere, even at the police post near his home. He will still appear there if he's summoned, because he is a person who respects the law. With those, I pray that you dismiss the application, but Mr. Biko will sum it up, and then Mr. Asap will do 1 minute.
Your Honor, in furtherance of the submissions by Mr. Karanja, permit me to state as follows. There is no charge sheet before you, upon which information as to what he has done will be captured. The police himself here has said that they accessed his home in Kuresoi, unhindered, unprevented. It is on that very basis that the same police can still go back to his home unhindered, unprevented. They confirmed that they indeed arrested 36 people, or about 56, who have since been arraigned before court. And Your Honor, on similar basis and terms, the courts before you, your learned brothers and sisters, released them. I'm reminded it's you. I'm actually reminded it's you. So now with that, let me arrest this issue. The police have had this habit of arresting people and detaining them while they take their sweet time to investigate and do whatever they want in political cases, as this is. See it for what it is. Other than Mutai, they have not told you anybody else within the same caliber and control level they have arrested, other than those young men who are mere collaterals. He has also not told you who on the other side, who are chasing Mutai out and why they have not been arraigned or arrested. But a person who can surrender himself to the police, as they have admitted, sure, will surrender at any place. And he is privileged enough to have counsel. We will bring him ourselves if they doubt themselves. Let me make this clear. There is no felony in these charges. They have talked about vehicles. Vehicles could have been burnt by anyone other than Mr. Mutai. None has said that they saw him burn any vehicles. None has said they saw him shoot anyone. And if anybody was shot at that time, it could have been even guns from the other side, because the persons there were equally of high caliber and gun holders. Why did they isolate him against Article 27? Discrimination, ultimately for political ends. You know, they are talking about people who are sick in the hospital. No single patient has been identified and as to which hospital that patient is. So that even as they accuse him of interfering with patients, how would he interfere with a patient he does not even know and the hospital they lie? Against all impossibilities, he's a member of parliament with statutory duties, including to budget for the funds he's using here. He should be a responsible police officer to appreciate that even the vehicle which brought him to court and the machinery he's using is budgeted for by him. And the budgeting season is now. Sadly, they're telling you he was a persona non grata in his own constituency in a school he has built. Is that not provocation? Is that not malice? Then where do you lay the malice forth? Bring it to court so that you flex muscles. Lastly, he's entitled to bail. But we are not even telling you to give him bail. We are asking you to give him personal bond on personal cognizance. Literally everybody here can identify him. Not even we advocates can be as much identified as he is. Not even yourself. A lot of people will pass you by the corridors over here, but they will not pass him. That's just how unique he is, to be identified in a public glare. And Your Honor, I surrender and conclude by submitting that you give us about 20 minutes break to come for a ruling to have him go back home. We will bring him whenever it's required. That's all.
I think my learned friend, Mr. Safa, said he doesn't want to conclude. I will wrap up, and I will ask you to, as Honorable Mutai lives here, you tell him what late Justice Madan told Stanley Munga Githunguri, that when he leaves this court, he goes back, he looks at Mau Hills, and he thanks God, the God of Assis, because we have a court and we have the Constitution, which guarantees his freedom and his rights. We close and ask you, as I repeat what Mr. Biko has said, I believe one of the reasons they brought the charge in the afternoon is to ensure that you deliver your ruling tomorrow so that you can spend the night. Don't fall into that trap. I pray, deliver the ruling, whatever the orders, make them so that on Mutai. And by the way, when Mr. Biko was saying that nobody can pass, he's the tallest here, even among us. So he can't pass anywhere. He's extremely tall. You can see. Thank you, Your Honor.
I like the poetic. Yes, Ms. Moyon. You also be poetic.
No, yes, I do appreciate the sentiments by my colleagues and the senior counsel, Mr. Karanja. And I do wish to submit that both the three councils have placed reliance on Article 49 of the Constitution. And my submission is that we have discharged our duty not later than 24 hours after arrest. That duty has been discharged. The suspect has been presented before court before the lapse of the 24-hour rule. Secondly, Article 49(1)(g) requires that a suspect at the first court appearance to either be charged or be informed of the reason for the detention continuing. Although we do not have a charge sheet before this court, the application before you, in the application before you, we have listed several grounds or reasons why I intend to have him detained further than the 24-hour period. The offenses, the possible offenses that may be preferred upon completion of investigations have also been disclosed. For that reason, that burden upon us have also been discharged. We do ask that the court do consider our submission, our application and submissions, and grant the orders prayed. That's all. Yeah.
I believe English will be appropriate in the circumstance. So this is a ruling in respect of a notice of motion application dated 23rd of June this year, brought pursuant to Article 49, Subarticle 1F and G of the Constitution of Kenya 2010 and other enabling provisions of the law, which the applicant through the Directorate of Criminal Investigation Kuresoi Note 6 custodial orders to detain the respondent for a period of 21 days pending completion of investigations. The application as drawn is premised on allegation that the respondent, jointly with others not yet arrested, is under investigation for offense of arson contrary to Section 332A of the Penal Code, malicious damage to property contrary to Section 3391 of the Penal Code, and assault causing actual bodily harm contrary to Section 251 of the Penal Code, allegedly committed on 19th of June 2026 at Umoja Tuluet Senior School during an event organized within Kuresoi North Sub-County. It is alleged that a motor vehicle registration number KDQ 155G, an Isuzu minibus, was set ablaze, and that other motor vehicles, including a government vehicle registration number KGB 253Z and a Toyota Prado registration number KDV 444A, were maliciously damaged. Further, it asserted that 2 persons sustained gunshot injuries and are admitted in hospital in critical condition. The grounds in support of the application as well as the supporting affidavits run by Inspector Polycarp Magai indicate that the continued detention is necessary to enable the investigation agency conduct valuation of the damaged properties, recover the respondent's firearm for ballistic examination, record statement of witnesses allegedly admitted in hospital, carry out identification parade, prevent interference with witnesses, facilitate medical examination of victims, and afford the investigation time to carry out comprehensive investigations. The application was presented by the Learned State Counsel Ms. Boyon through the investigating officer IP Inspector Polycarp Magai, and was vehemently opposed by the Learned Counsel Mr. Karanja, Mr. Guto, and Mr. Biko for the respondent. At the hearing, the deponent, Inspector Polycarp Magai, was extensively cross-examined. In the course of that cross-examination, he candidly stated that at the moment, the investigators had not made a determination to charge any person, notwithstanding the prayer to detain the respondent for 21 days. He further struggled to explain how the continued detention of the respondent would facilitate valuation of the allegedly destroyed motor vehicles, and was unable to satisfactorily demonstrate how the respondent would interfere with witnesses. It also emerged that the police had already assessed the respondent homestead and effected arrest of other persons without any hindrance while the respondent was not in custody. The investigating officer was also unable to justify why evaluation was to be undertaken by a valuer from Nairobi as opposed to Nakuru. On the issue of recovery and surrender of firearm, he referred to a prayer that was not contained in the application, and upon being pressed, was unable to demonstrate that such a prayer really existed. Notably, despite being a police officer, he could not adequately explain the legal process governing surrender of a licensed firearms. With regard to the alleged victims admitted in hospital, the officer confirmed that he had no documentary proof before the court to establish the existence of such victims or their injuries. He further confirmed that the respondent had been summoned by the County Criminal Investigation Officer, as the CCIO. Sorry for my S and C's. I think it's a mother tongue influence. Voluntarily presented himself, recorded a statement, and was thereafter placed in custody, leading to his arraignment before this court. On the issue of identification parade, he considered that the respondent is a public figure, being a member of parliament and well-known within Nakuru County, thereby casting doubt on the probative value of any proposed identification parade. He relied largely on intelligence report, which he declined to disclose. In submission, the learned counsel, Mr. Karanja, for the respondent, opposed the application and relied on the decision of Michael Rotich versus Republic of 2016, where the High Court emphasized that continued detention is a limitation of the constitutional right to liberty and can only be granted upon demonstration of compelling reasons. He also submitted that no such compelling reason had been advanced, arguing that the grounds cited by the applicant, including valuation, ballistic examination, identification parade, and the alleged hospitalized victims without supporting documents, did not meet the constitutional threshold. Counsel further submitted that the respondent, being a sitting member of parliament, will suffer prejudice if detained for 21 days, as this will affect his representation of his constituents. Mr. Biko, in supplementing the opposition, argued that no charge sheet had been presented to demonstrate the nature of the allegation confronting the respondent. He pointed out that the police had already assessed the respondent resident and conducted operations without interference, hence the allegation of possible obstruction was unfounded. He also criticized what he described as a growing trend of using custodial detention as a political tool, terming it discriminatory. In reply, the learned counsel, Ms. Boyon, urged the court to find that the burden under Article 49 had been discharged and the orders sought were necessary to enable completion of investigation. I've carefully considered the application, the supporting affidavit, the oral testimony of the investigating officer under cross-examination, the rival submission by the learned counsel, and the starting point is Article 49, sub-Article 1F of the Constitution of Kenya 2010, which guarantees an arrested person the right to be brought before a court as soon as reasonable possible and not less than 24 hours. Under Article 49(1)H, which secures the right to be released on bond or bail on reasonable condition unless there are compelling reason not to be released. Continued detention prior to charge is therefore a serious limitation of the right to liberty and must be justified by cogent, specific, and verifiable reasons. The jurisprudence in this respect is Republic vs. Ahmad Abul Fatih Mohammed and another 2018 EKLR and Michael Rotich vs. Republic 2016 EKLR. It's clear that burden lies on the prosecution to demonstrate compelling grounds to warrant curtailment of liberty. In the present case, several concerns arises. First, the IO, that is Inspector Magai, expressly confirmed that no decision has been made as to whether the respondent or any other person will be charged. This raises question as to the basis upon which this court is being asked to deprive a citizen of liberty for 21 days. Secondly, the ground advanced in the application are not supported by cogent evidence. There is no documentary evidence to confirm the alleged hospitalized victims, their injuries, or their inability to record statements. Sorry. The claim that an identification parade is necessary is undermined by the admission that the respondent is well-known public figure. Thirdly, the assertion that the respondent will interfere with witnesses remains speculative. No specific witness can be identified. No factual basis has been laid to support that apprehension. On the contrary, it's evident that the police have already conducted operations, including assessing the respondent's homestead without obstruction. Fourthly, the prayer relating to recovery of firearms and ballistic examination is not anchored in the application, and if it were, the IO was unable to explain the legal procedure relating to license firearms. Fifthly, the justification for valuation of damaged property does not logically require the continued detention of the respondent. Similarly, the explanation as to why such valuation must be undertaken by a valuer from Nairobi rather than locally was unsatisfactory. The court must guard against converting pre-charge detention into a tool for fishing expeditions or speculation. The Constitution demands accountability and precision in limiting fundamental rights. In Republic versus Danson Mungunya and another 2010 EKLR, the court held that mere suspicion, however strong, cannot justify deprivation of liberty. In the present circumstance, I find that the applicant has failed to demonstrate compelling reason to warrant the detention of the respondent for 21 days or at all. The reasons advanced are either unsupported by evidence, speculative, or unrelated to the necessity of detention. In that case, the court makes the following orders in the interest of justice. Number one, the application dated 23rd June 2026 seeking orders to detain the respondent for 21 days is hereby dismissed. The respondent shall be released on bond of Kenya shillings 100,000 with one surety of similar amount. In the alternative, and without prejudice, he will be released. Respondent shall be released on a cash bail of Kenya shillings 50,000. And in that one also add that he also provide us with a contact person who shall also act as a surety in as much as it's a public figure. The respondent shall report to the investigating officer every Monday, despite his busy schedule as a member of parliament, Wednesday and Friday, or they may agree with the IO until the expiry of the 21 days that was sought. The matter will be mentioned after the lapse of the 21 days for further orders. Believe that will take us to 13th or 14th, Mutai? 14th.
As the respondent actually is processed, we can remain in court instead of being taken back to the police station.
That one you can arrange with because I'm seeing there's some chaos outside there.
Your Honor, substantially why we are praying for that is because of the chaos there. We are better off here without interfering in the process. We will contain them as you guided us. We are just cautious of time and we will pay.
Just talk to the officers who are managing
We have discussed it earlier, and it's just good for both the police as well as the public. We will contain them. All we wanted was this liberty, and thank you so much.
Kindly ensure that nobody's
And Your Honor, I don't know whether you've already uploaded.
They're saying that because of the process of...
As you sit there.
Very. Thank you, Your Honor. I think the last time I was in this court, it was a long time ago. Yes, and I was reminding your assistant that in 202, you were watching football with the Majesty. It was sitting here. There was a hotel here. We watched Senegal versus... As the respondent actually is processed, we can remain in court instead of being taken back to the police station.
That one you can arrange with because I'm seeing there's some chaos outside there.
Your Honor, substantially why we are praying for that is because of the chaos there. We are better off here without interfering in the process. We will contain them as you guided us. We are just cautious of time and we will pay.
Just talk to the officers who are managing
We have discussed it earlier, and it's just good for both the police as well as the public. We will contain them. All we wanted was this liberty, and thank you so much.
Kindly ensure that nobody's
And Your Honor, I don't know whether you've already uploaded.
They're saying that because of the process of...
As you sit there.
Very. Thank you, Your Honor. I think the last time I was in this court, it was a long time ago. Yes, and I was reminding your assistant that in 202, you were watching football with the Majesty. It was sitting here. There was a hotel here. We watched Senegal versus...
And as stated by the poetic councils, I should not be swayed to sleep with it. Yes, I told you that in the next few minutes
I'll be through with it. Yes.
Profoundly
So,
grateful.
we can have a short break, about 10 to 20 minutes. I'll give you the verdict.
Thank you so much.